It is true that I sent a letter on the 10th of June this year to Eric Holder to ask very precise questions. It is true that some of these questions have been answered in our meeting in Ireland. It is also true that not all of the questions have been answered. That is why my colleague Malmström and myself, we have written a letter again to the Attorney General and saying the following. At our meeting, we were not yet in a position to answer all the questions set out in the letter of 10th of June. Given the strength of feeling and public opinion on this side of the Atlantic, we should be grateful if you would communicate your answers to those questions as soon as possible. We are particularly concerned about the volume of data collected, the personal and material scope of the programme, and the extent of judicial oversight and redress available to Europeans. So this is one part of the discussion. The other part is this group which is to be created. Cecilia and myself, we have asked that the initial meeting of this group should be in July. So not a group at Kalendas Grekas, but a group now. But the answer to the letter before that group meets. So far, and yes, the statement which I gave after the meeting with Eric Holder is the official statement of the Commission in that respect. I hope, President, that all the members of this committee can get this official statement. Now to the very specific questions which have been asked on how the data protection rules were elaborated in the Commission. Now you know that 18 months ago the Commission put on the table a proposal, and that is the proposal by the Commission. All former drafts are not the proposal of the Commission. Now coming to the specific question which was asked, and that was about one article which had been in one of the drafts. I don't know, you call it the Article 42. Now if you read recital 90, you will see that this is inside the draft regulation. Very clearly, the law enforcement authorities in third countries have to ask information via legally established channels. And legally established channels is the MLA. I know that in this Parliament there are amendments on the table in order to make out of this recital an article. Well, I will ask Parliament to take its responsibility. If the Parliament thinks that out of the recital there should be made an article, so be it. I have no objections to this. And I would like to say that the Patriot Act, since 2011, in all meetings with the Americans was put on the table. Because if you do not go through the MLA, if you are going directly to companies asking data of European citizens, that is a violation of international law. I've said it again and again, and this has been reflected in recital 90. Now saying something about intelligence. Of course, intelligence is not in our remit, but if you read the statement after the Holder meeting, it said very clearly in this statement also that even in questions of intelligence, the fundamental rights which are inscribed in our basic text are not eliminated. They have also to be considered. So the position of the Commission and the defence of the fundamental rights of the citizens is without any doubt in that respect.